Hello, AP NSL students. I'm Peter Cirincione, and my disembodied head in the corner is going to be your guide through this lesson that focus on the First Amendment, particularly the speech and press clauses, the protections offered by those clauses, the substantial and numerous limitations on those protections, and how the Supreme Court of the United States has interpreted these clauses over time, particularly in 4 essential cases that you are expected to truly understand the facts of the arguments made and the constitutional basis of those arguments. Throughout this lesson, I'm going to be using in this presentation a number of images that come from the fantastic graphic adaptation of the United States Constitution. It's linked in the slides that you should be able to access along with this lesson. And I do encourage you to take a look at it. And I will also note that the First Amendment is in fact protecting my use of this, and though there are copyright limitations, the fair use doctrine definitely incorporates what I'm doing with this lesson here. So again, those 4 cases that we're going to go into in some detail in this lesson later are Schenck v. US, New York Times Company v. US, Citizens United v. FEC, and Tinker v. Des Moines. The College Board has aptly focused what you need to know on a few different learning objectives. This one actually quite well encapsulates the true essence of why it's important to understand the First Amendment, one of a number of civil liberties, those things protected in the Bill of Rights that would really be better termed the Bill of Liberties, because these liberties are freedoms from government abuse, as it says here, arbitrary government interference in these freedoms, because these freedoms, especially, you may recall, according to Locke and Rousseau and Jefferson and many American philosophers after them, these freedoms are not given to us by the government. They are inherently our freedoms, and the government cannot take them away based on the Bill of Rights. And the Bill of Rights, those first 10 amendments to the Constitution, is truly an essential part of that Constitution. And although it was made after the Constitution was ratified, the very ratification of the Constitution was presupposed on these liberties being written into the Constitution, because the Anti-Federalists felt this was absolutely essential, that the government not be allowed to turn into a 3-headed tyrannical Cerberus, in which these 3 branches trampled over the individual liberties of citizens. So they made contingent their support of ratification on the passage immediately thereafter, and it was passed almost immediately after ratification, this Bill of Rights. And the Bill of Rights restrains the government, and what we focus on is where and what cases the government is restrained from limiting speech, because like with many liberties, there's this constant balance being struck by the Supreme Court, by Americans writ large, between freedom and security, or individual liberty and government power. And we're going to see that these sides are at various points more or less privileged by the Supreme Court. The First Amendment is, of course, the second most important amendment after the, I'll wait for you to answer it yourself, 14th Amendment. Did you get it? Well, it's the 14th because of the incorporation doctrine, which hopefully you understand from the previous lesson. But without the incorporation doctrine, this first clause of the First Amendment, Congress shall make no law, would mean that these protections would only protect Americans from actions of the federal government. But thanks to the 14th Amendment, incorporating these protections to cover the states, the First Amendment, and all the rest of the liberties enshrined in the Bill of Rights are protected from government restriction at the state and federal level. and local level, of course. The First Amendment has 5 key freedoms enshrined in these really 6 important, you should know them by name clauses: Establishment Clause, Free Exercise Clause, Speech, Press, Assembly, and Petition clauses. We're going to be focusing on these 2 highlighted in yellow: freedom of speech and freedom of the press. When we're talking about speech, the most sacred, most protected of all forms of speech is political speech. And when we're talking about speech, it could be spoken, written, or symbolic, a work of art, or, I don't know, an armband, perhaps, worn to express political sentiments. These are all protected forms of expression. The fact that our First Amendment protects our expression from arbitrary government interference is great. But that protection is not absolute. Clearly, there has to be some balance between individual liberty, freedom to do what you want, and government power to ensure security and the freedoms of others in the community. That social contract has to be maintained. And what body is it that draws these lines in the gray areas, that determines just how to weigh these competing valid concerns? Well, it's the Supreme Court. And they have, over time, established a number of criteria for determining what kinds of speech are protected and where can the government actually limit your speech. Well, here's some cases. Some of them are going to be further outlined in the cases that we focus on for the AP exam. All of them are important for being a citizen in the United States. One type of speech that isn't protected is speech that presents a clear and present danger. Speech that has the potential to immediately cause harm to be done. The government can also limit speech that is obscene, obscenity. But this is very subjective. The Supreme Court has had a hard time and is continually updated, but the standard that you should know comes from Miller v. California, and the Supreme Court laid out that if an ordinary person applying contemporary community standards would find some content appeals primarily to prurient interests, deviant, sexual, violent, disgusting interests, and on the whole lacks artistic, literary, or scientific value, then it could be considered obscenity and banned or restricted. You could also not legally defame someone. Defamatory speech or defamation can also be regulated by the government. And defamation is untrue speech, spoken or written, with malice. That's important. Against a person that can harm their reputation. If it's said out loud, it's slander. If it's written, it's libel. Similar, but not identical to clear and present danger are fighting words. And Brandenburg v. Ohio, 1969, established that speech that is likely to incite lawless action, if somebody says something that immediately leads someone to commit a crime, that is not permitted. That can be banned. There are restrictions on commercial speech, especially things like truth in advertising that might be enforced by the FTC. And there are places where your speech protections are not so grand, most notably in schools, as we'll get into with Tinker v. Des Moines, but also on military bases and prisons. The government has greater leeway to limit your speech. Graphic adaptation of the Constitution has some nice summary of these limitations. They can all be captured pretty well by the image that's in the top right corner and on the front page of this slideshow, that the right to swing my fist ends where the other man's nose begins. In general, this balance is struck by looking at where does one person's speech start to infringe on the rights of somebody else, start to get in the way of some other person or group living out their life as they should be able to freely in our society. So where that zone of nose and fist connection, that's the place where the government can regulate and make laws actually limiting speech. When people start expressing things in ways that harm others, that's what can be limited. Now we get into our first of these 4 cases, Schenck v. US. And this and the slides for many of the other cases are substantially modified by myself, but a lot of them were initially crafted by students in my classes in past years. The context for Schenck is extremely important. The US entered World War I in April 1917. Just 2 months later, Congress passes the Espionage Act, which defined espionage, which attempted to give the government the power to stop efforts to interfere with, to sabotage the US efforts at war. At this time, this was the Red Scare. Popularly in the United States, socialists and anyone opposed to the war effort as well was viewed as anti-American and most likely traitorous. This is depicted in the political cartoon here. This popular idea that ideas espoused by socialists would inexorably lead to the destruction of the country, that the question of what to do with the socialists and communists was an existential question for the United States. And this is really important for considering why the Supreme Court ultimately in this case decides to allow the government to restrict speech in this case. As the US war effort ramped up, a draft was instituted. And the Socialist Party and a prominent member, Schenck, found this to be deeply offensive, and they started to try to rally opposition to the war and particularly to the draft. And Schenck distributed a pamphlet which encouraged people to oppose the draft, to destroy their draft cards. And they based their argument upon the Constitution, arguing that the 13th Amendment, which prohibits slavery and involuntary servitude, was being violated by this draft. Writing a conscripted citizen is forced into involuntary servitude, deprived of all freedom of conscience, and being forced to kill against his will. And they appealed to all readers to assert and support your rights, and really argued in favor of doing this on the basis of the First Amendment itself. So it's perhaps particularly ironic that that amendment was insufficient to keep Schenck out of jail. So the constitutional issue raised in this case was this: does criticizing and encouraging opposition to the draft constitute protected speech under the First Amendment, or is it legitimate for the government to ban such activities during wartime? In the case, Schenck's side argued that the 13th Amendment eliminated involuntary servitude after the Civil War, and this draft was forcing people to act against their conscience and their will, and therefore violate the 13th Amendment. They also argued that the First Amendment protects free speech. There is no exception within the First Amendment that says, well, not if there's war. It's all the time, they argued. And that the Espionage Act violated the First Amendment by banning huge swaths of speech and expression, and was far too vague and far-reaching to hold up under scrutiny. The US, on the other hand, argued that the draft is absolutely necessary for the nation to defend itself, that there is this balance that obviously must be maintained between security and individual liberty. In this case, the court should come down firmly on the side of security, and the primary and highest purpose of government is to protect its citizens, to maintain national security. And the Espionage Act was simply a means of letting the government do this, carry out this role. And the court decided unanimously in favor of the United States. Justice Oliver Wendell Holmes wrote the opinion of the court and has a number of statements that continue to echo through jurisprudence, through the precedents they set, and then how this case has been responded to since. He wrote, "The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing panic." Goes on, "The question in every case is whether the words used are used in such a circumstance and are of such nature as to create a clear and present danger that they will bring about the substantive evils." He is really saying that this speech cannot be protected because it is dangerous. It presents an obvious danger, and it's going to bring about clear bad things. And it is within the government's legitimate use of its powers to restrict such obviously dangerous expression, particularly during wartime. He wrote, "When a nation is at war, many things that might be said in times of peace are such a hindrance to its effort that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right." This case had profound impact. The scales shifted decisively towards government power in this balance between individual freedom and security as held up by the government. It had a chilling effect on anti-government speech, though over time, society and the court would lean more and more towards that side of individual liberty, particularly in a case that we're going to come to next, the New York Times Company v. U.S., in which one of the opinions justices wrote that the word security is a broad, vague generality whose contours should not be invoked to abrogate the fundamental law embodied in the First Amendment. Schenck really would have loved it if that had been the view of the court in 1919. And later, the privileged position of political speech be further elevated by the Citizens United decision in 2010, in which one of the opinions written, political speech must prevail against laws that would suppress it, whether by design or inadvertence. Because speech is not just speech, but it is fundamental to our participation in our democracy. So since Schenck, the court, public opinion have really shifted towards protection for unpopular speech. Even if the current government doesn't like it, the current administration, even if it is that speech is against something that many people support, the prevailing view of the court and the general public is that most speech should be protected because it is essential for political liberty. Now we come to New York Times Company v. U.S. It's argued 1971. In this case, it comes down to whether the Pentagon Papers, these trove of documents that detailed what the United States had really been doing in Vietnam, what the circumstances, what the conditions, the assessments of potential for victory or something approaching it really were. When Daniel Ellsberg started leaking these papers to the New York Times and they started publishing it, the Nixon administration sought an injunction, sought prior restraint. They wanted to prevent the publication of more of these papers, and they went to the courts to try to get this action, to stop the New York Times from publishing more of these documents that they felt were damaging to the ongoing war effort, not to mention their political prospects. The constitutional question raised here is the First Amendment protection of the freedom of the press subordinate underneath the need of the executive branch to maintain secrecy on matters of national defense? Again, is this tool of the government, this legitimate need for the government to protect people? How far can the government use arguments of national security, national defense in efforts to restrict individual freedom? In this case, they looked back at precedents, including Schenck v. U.S., where the court tried to determine, was the publication of the Pentagon Papers a episode of clear and present danger? And the court looked back at precedent and statutes as they considered this case, including Schenck v. U.S. decision in 1990, as the court sought to determine, did the publication of the Pentagon Papers present a clear and present danger? They also looked at Neer v. Minnesota from 1931, the case that incorporated the First Amendment freedoms of the press to the states, and in which the court at that time upheld the ability of papers to take actions that government officials thought hurt them. They also looked at the Espionage Act, that act that Schenck was convicted under, that gave the government massive powers of censorship, particularly when it came to foreign affairs. The U.S. argued that this Espionage Act made the Pentagon Papers a document that could be used to the injury of the United States or the advantage of any foreign nation, and thus it could be legally censored. Fundamentally, they are arguing that the publication of these documents was giving aid and comfort to the enemy, that was basically treasonous, that was going to lead to death and injury to American service members, and was harming the ability of the administration to protect the American people. The New York Times argued basically that the government carries a heavy burden of showing justification for the imposition of such a restraint, quoting Neer v. Minnesota. And the Pentagon Papers are not nearly sufficient in how much damage they would do to the U.S. interests to invoke prior restraint. That this bar for the government preventing the publication of something, preventing from ever being expressed to the public, needed to be set very high. And in this case, that bar was not reached. The court decided in a 6-3 decision, in which the Chief Justice at the time, Warren Burger, was in the minority. It was a per curiam opinion. Again, per curiam means of the court. It's an unsigned opinion. And in this case, and most cases, it's very brief. And the per curiam opinion of the court stated that the Pentagon Papers didn't meet the burden of justification for prior restraint. They simply weren't bad enough in the damage they might do to national security to allow the government to prevent them from being published. And they wrote, quote, "Any system of prior restraint comes to this court bearing a heavy presumption against its constitutional validity. The government thus carries a heavy burden of showing justification for the imposition of such restraint." Again, quoting Neer v. Minnesota. Justices Black and Douglas wrote a concurring opinion that was extremely strongly worded, and they not only supported the decision, but took pains to go after the US's argument, saying this was really a dangerous action, that this set a precedent for administrations to use security in such a broad frame that it would allow them to do almost anything to limit speech. writing, "The word security is a broad, vague generality whose contours should not be invoked to abrogate the fundamental law embodied in the First Amendment." Furthermore, they went on, "Only a free and unrestrained press can effectively expose deception in government. Paramount among the responsibilities of a free press is the duty to prevent any part of the government from deceiving the people." I'm going to come back to this. Meanwhile, Chief Justice Berger wrote a dissenting opinion in which he mainly articulated that this case had gone too fast and didn't allow the U.S. to fully develop its argument, and then they should have spent more time on it. Many see this as really reflecting more that Berger had very recently been appointed by Nixon and still felt a certain loyalty to the administration. So this case is important because it reinforced some precedent that, again, there's a heavy presumption against prior restraint, and that the First Amendment really was substantial in protecting the press from government censorship, and that there was a very high bar that the government had to reach if it wanted to ban the publication of something. And saying something is in the national security interest isn't enough. And this demonstrated profound shift over time from when Schenck was decided in 1919. And what changed in this time? Clearly a lot, but perhaps most importantly, trust in government. The deference given to government, the presumption that what the administration would be attempting to do would be justified, was gone. Further, just what it meant to be in war substantially changed. This wasn't World War I or World War II. This was this ongoing quagmire that was never actually declared war. So if we're going to give the government expanded powers in wartime, what if wartime is all the time? And this also showed that in this time, views of where the balance should be struck between individual liberty and government power had shifted significantly towards individual liberty. We'll come now briefly to Citizens United v. FEC from 2010. And we're going to hit on this case quickly because it was covered significantly early in the year for my and other Blair AP and NSL students. But it's worth focusing on because how much of this case truly turned around views of speech and how much political speech should be protected. And the court decided this case in a split 5-4 decision. Justice Kennedy, who was so often a swing justice, penned the opinion, and Kennedy was also particularly known for being a vehement defender of First Amendment protections. And he wrote that political speech must prevail against laws that would suppress it, whether by design or inadvertence. Laws that burden political speech are subject to strict scrutiny. It's going to come up a lot when we talk about civil rights, which requires the government to prove the restriction furthers a compelling interest and is narrowly tailored to achieve that interest. And then now he comes back to getting at the purpose of the First Amendment. Premised on mistrust of governmental power, the First Amendment stands against attempts to disfavor certain subjects or viewpoints. Prohibited, too, are restrictions distinguishing among different speakers, allowing speech by some but not others. Speech restrictions based on the identity of the speaker are all too often simply a means to control content. So in this case, we see some real stark contrasts with Schenck and some real continuity with the New York Times v. US. When it comes back to Schenck, in this case, the court sided distinctly with individual liberty over governmental power. And prefaced political speech by that individual over the desire by the government for some particular outcome or overall societal impact. This isn't about war powers or national security. It does get at just how sacrosanct political speech now is, which was not the case when Schenck had his case before the court. Now, when it comes to the New York Times, the US, Citizens United follows in its footsteps by maintaining a really high bar for what the government needs to show if it wants to limit political speech. And in part of the decision, Kennedy wrote, these onerous restrictions thus function as the equivalent of prior restraint by giving the FEC power analogous to licensing laws implemented in the 16th and 17th century England. He's drawing this connection between kind of prior restraint that was attempted by the US in 1971 to what the FEC is doing by limiting the speech of certain groups, in this case, corporations and unions. So this Citizens United case can really be seen in this First Amendment light, these two ways. One, saying equal speech is not what is protected in the Bill of Rights. It's free speech. Just because we may desire a society in which everyone has equal political power or equivalent power, that is not what the Constitution protects. So even this was an unpopular decision, particularly on the left, Citizens United has very strong constitutional basis. And two, you can see this case as a step in this progression of the court and U.S. society towards greater preference for individual expression and freedom over governmental power. And that brings us now to Tinker v. Des Moines. Doing this out of chronological order because this really fits differently in the grand scheme of things than the grand scheme of things in these other cases. This is particularly a case about student speech. In this case, in 1965, Christopher Eckert and Mary Beth Tinker planned to wear black armbands to school to protest the Vietnam War. They told others about this. It became common knowledge, and Des Moines school officials decided that students would be asked to remove the armbands or face suspension. When they actually wore them to school, Mary Beth and her brother John were sent home, and they did not return for weeks. The students and their families ultimately sued the school district for violating their First Amendment rights, and they sought an injunction against the school district to protect their students, a motion from the court to say you have to stop this type of action. This case hopefully resonates with you because it applies to you right now, your particular rights while you're in school. And well, just like Mary Beth Tinker, you also learned and are learning about the Bill of Rights. And they felt that free speech should apply to kids too. The question in this case ultimately was, does the First Amendment protect students' rights to express unpopular political opinions or views while in school? Does the First Amendment cover students? In this case, Tinker's side argued that freedom of speech, particularly symbolic speech, should absolutely be protected in schools under the First Amendment. The fact that it was school shouldn't change the fact that the First Amendment is part of the Constitution. They further went on to say the armbands didn't create unsafe conditions or interfere significantly with learning, so there's no good reason for them to be banned. The Des Moines Independent Community School District argued that schools are for learning, and these armbands, this protest, was not towards that end. It disrupted learning, and therefore was within their purview to ban such displays. and that discipline itself was important. If students started just refusing to obey rules based on their personal desires for expression, there was a slippery slope towards chaos and the destruction of the general learning environment. This case was a 7-2 decision in favor of Tinker. The court ruled they had the right to wear these armbands, that these armbands were an example of pure speech, and we're going to get back to this, but students don't lose their rights when they go onto school grounds. Justice Fortas wrote the majority opinion. There are some particularly notable and powerful quotes from this opinion that really drive home the grounds for this decision. Justice wrote, First Amendment rights applied in light of the special characteristics of the school environment are available to teachers and students. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. It's reiterating that there's no magic that happens when you cross into school that means that you stop being protected by the First Amendment. Moving on. A student's rights, therefore, do not embrace merely the classroom hours. He may express his opinions even on controversial subjects like the conflict in Vietnam if he does so without materially and substantially interfering the requirements of appropriate discipline in the operation of the school and without colliding with the rights of others. In order for school officials to justify prohibition of a particular expression of opinion, it must be able to show that its action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular view. Justice Fortas is articulating here the bar that school officials must reach if they desire to bar speech. They have to be able to show that it materially and substantively interferes with appropriate discipline in the operation of school, and that is not just an attempt to silence a student that is saying something they don't like. The outcome of this case is frequently misunderstood by students. They frequently remember only the first part of the parameters set by the Supreme Court in this case, that First Amendment protections cover students. They often remember that, quote, students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. But this case also sets the other end of this. They said there are limits. Schools have a compelling interest. What are the criteria for passing muster under strict scrutiny? Have a compelling interest in educating, and they can limit student speech if it has the effect of, quote, materially and substantially interfering with the operation of the school. So, yes, you still have First Amendment protections in school, but when you pass through the schoolhouse gate, when you go onto school grounds, there is now a lesser protection for your free speech rights, because it's not just that you can't have obscenity or fighting words or present a clear and present danger, but also if you substantially or materially interfere with the operation of the school, with the ability of the school to carry out its compelling interest, then your speech can be limited. So it is easier for your speech as a student to be legally and constitutionally curtailed by government authorities than it is if you're off school grounds and are just a private citizen. So let's recap. Let's get at the headlines for each of these cases and the connections between them to help you forge and solidify your understanding of these cases and those connections that will help you recall and utilize these cases, whether you're called upon to reference them on a FRQ on the upcoming AP exam. And as of the recording of this video, we still aren't sure exactly of the format or what questions will be asked. Or in actual life, when you will be going around this country. And it is essential for your full citizenship that you understand the true bounds of your free expression rights. So, Schenck v. US. The headline: the government can restrict speech that presents clear and present danger, especially in times of war. How is it connected to other cases? This case added to government power, while each of these later cases ended up limiting the government power in comparison to individual liberty. New York Times Company v. US. A high bar was set for prior restraint. Just being related to national security, that's not enough. How is it connected? Well, this case permitted more speech that the government dislikes, unlike Schenck, but in line with Citizens United. And Citizens United, VFEC in 2010. Headline: money is speech when it comes to electioneering, when it comes to getting involved in campaign financing. And corporation unions can't be limited differently when it comes to this speech than other groups or individuals. You might be able to limit some campaigns finance, but you can't limit these groups differently. The connection to the other case: political speech is the most protected form of speech. This case expands liberty, like New York Times v. US and the Tinker case, and unlike Schenck, which expanded government power. Citizens United, once again, said there are limits to what the government can do to restrict speech. Finally, Tinker v. Des Moines. The headline from this is that students have free speech protections, but there are limitations. Now, the key limitation is your speech could be restricted if it significantly disrupts the learning environment. Connection to the other cases is, like New York Times Company versus the US, the government wanted to restrict speech that was contrary to the Vietnam War effort, but the Supreme Court ruled the government needs truly compelling reasons if it wants to limit speech. Inconvenience, opposition to their policies is not enough. I hope this was helpful. I hope you understand your First Amendment speech and press rights better than you did before. And I know that you'll do very well in showing what you know on the AP exam.